This podcast is brought to you by Customplan Financial Advisors, Inc., an independent insurance managing general agency in Canada. Financialpodcast.ca was developed with one goal in mind: to educate Canadians on important topics that affect their financial well-being and make it readily available to all. We welcome you to plug in and learn with us. If you have questions, please email us at contact@financialpodcast.ca.
Hello and welcome to the Financial Podcast. My name is Gary Poyer. The Financial Podcast is sponsored by Customplan Financial Advisors, an award-winning MGA that provides fantastic support and resources to the independent financial advisor. Please visit customplanfinancial.com to see all of the resources that are available to you as an independent financial advisor. Today, our focus will be on powers of attorney and personal directives. And we're extremely happy to have as our guest, Jennifer Lamb. Jennifer is a partner with law firm Carscallen LLP in Calgary. Welcome, Jennifer.
Well, thank you so much, Gary. It's my pleasure to be on the podcast this morning.
Okay, Jennifer, why don't you tell us a little bit about yourself and your background?
Absolutely. So I was called to the Alberta bar in 2004. I've had a varied litigation career, starting with sort of commercial litigation and a lot of insurance defense matters. And as my practice developed, I was able to really begin specializing in wills and estates matters. It started off with a real focus on estate litigation. And so, as we call it in our world, family law after death. I was able to also develop expertise and a specialization in estate administration and estate planning. And so over the past 18 years, I've only practiced at two firms. I started at Carscallen. I practiced at Borden Ladner Gervais for 11 years. And then I came back to Carscallen about 4 years ago, really to develop our estate group into, our aspirations. We're a smaller regional firm, but our aspirations are to be the best estate planners and litigators in the province, and that we've got, the bench strength to really service our clients and make sure that they've got both, the proper planning in place, and then we're able to assist them if there are contentious matters after the death of a family member.
Okay. Yeah. One of the areas of financial planning that I enjoyed the most was estate planning because of the planning aspect. You have to think ahead with, if something happens to somebody, what are the ramifications of that? Or, if they're ill and they need a power of attorney. Do you know offhand what percentage of people in Alberta have wills or don't have wills and powers of attorney?
So I've heard varying statistics over the years, and I'm not inclined to really, think about the reliability of those, but it's actually, I could just say as a general comment, it's often quite surprising to me, the number of high net worth individuals, blended families, adult children from different marriages that either don't have any documents in place whatsoever, or their documents are outdated. So this isn't at all a criticism. No one likes to think about these topics. I mean, you're contemplating your mortality, you're thinking about, very difficult financial situations, you're thinking about challenging family dynamics. But I would say that the more work you can put into it at the front end to say, look, we're going to sit down, we're going to put a will, a personal directive, and a power of attorney in place, you're actually doing your family such a service by doing that advanced planning. And I can hear what you're saying, Gary, about, your fascination with the topic, because it just is so important.
Yeah. I find, the estate planning documentation, it's similar to life insurance in that it's more of an act of love, because you're doing it for the benefit of your family, and you're looking after assets as well. But to me, it's an act of love to have all those documents prepared ahead of time.
It is, Gary. And another interesting point I would want to raise in this discussion is oftentimes clients can feel quite conflicted in terms of how much information they want to share with their family about what the plan looks like, or rather they want to maintain some privacy and not tell their children or extended family member what the plan is. And I think that can be a very difficult decision for families. I think it's a case by case basis. My practice and my advice is always to encourage the lines of communication to be open, so family members aren't caught by surprise. There's, this desire for children to want to be treated equally. And we know in Alberta, unlike in BC and some maritime jurisdictions, there's an obligation to provide for adult children equally. We don't have that legislative scheme in Alberta. So there is really an emphasis on testamentary freedom. And again, that I'm getting into wills topics, but there is so much overlap here. I know we're trying to, stick to powers of attorney and personal directives today, but there really is such an importance on the entire plan, making sure you don't just have the will, but you also have the personal directive and the power of attorney in place that reflects one's wishes.
Yeah, I think a lot of people hear the term will. It's fairly common in our society. I think maybe power of attorney is less well known. So, Jen, what is a power of attorney?
Sure. So the power of attorney, or an enduring power of attorney, those terms are usually used interchangeably, is a document that comes into effect when it can either come into effect immediately, where you appoint a decision maker over all of your financial affairs, your accounts, your investments, your property. There's also the option to have it only come into effect on mental incapacity. So under this document, you appoint an attorney, or in certain cases, 2 or 3, although that can get complicated for other reasons, which I can talk about. But that is your decision maker over your financial affairs. There are a few different types. Some banks just have a certain power of attorney document over the accounts that one holds at that financial institution. The ones that we typically draft primarily come into effect upon incapacity. So I'll say I would like my partner to manage my affairs when 2 doctors can certify that I have lacked my mental capacity to do so.
Okay.
Other families may want to spend 6 months less a day out of the year down in the States in their snowbirds. And they want an immediate power of attorney over all of their assets just for convenience purposes. So they say, I'm going to appoint my son or daughter to be my attorney on an immediate basis, just to help me with my banking and my affairs while I'm traveling. So there's many different options. We try to be as creative as we can with the plan to make sure that people, our clients' needs are being met. And so that's the essential overview of what a power of attorney document does.
Okay. So there's more than one kind of power of attorney.
Exactly. And then just looking at it again from broad strokes, the personal directive, which is again a document that we may not be as familiar with when we talk about wills. The personal directive is the decision-making document that governs medical care, healthcare, personal decision-making. And it's important to note the distinction: the personal directive can only come into effect upon proof of incapacity.
Okay.
So it's really important to have those 2 documents in place alongside a will, because it essentially contemplates immediate needs for financial assistance. And in the event of incapacity, you've got the decision makers in place. Now, you might want to ask me, Gary, what if someone doesn't have these documents in place? What happens when they lose capacity, when someone loses capacity and they don't have documents, don't have these executed documents in place? Yeah. Oftentimes we have to bring a court application for guardianship and trusteeship, and that can be expensive and take lots of time. Yeah. And it's always, it's our backstop, if you will, but it's always preferable to have the personal directive and the enduring power of attorney in place as to avoid court applications.
Right. Okay. So there's the power of attorney for the financial aspect of things, and then the power of attorney for the health related one?
The personal directive for the healthcare decisions and the living, where you would want to live if you didn't have capacity. Is it a nursing home? Is it home care? What does that look like for you and your family members?
Okay. So if I don't have a power of attorney and I'm in a car accident, so I'm physically unable to look after my financial affairs, somebody has to go to court or on my behalf in order to gain authority to look after my financial affairs. Is that right?
That's right. It would be, usually we can do these, and our office does them all the time. These applications are pursuant to the Adult Guardianship and Trusteeship Act. They can usually be done by way of a desk application if they're not contested. But once again, they can take many months, and usually people can try to do them themselves without the use of a lawyer. That can often work as well, but it will take time, and these forms can be somewhat, complicated to navigate. But again, a lot of our practice at Carscallen is dealing with adult guardianship and trusteeship matters. So once again, it's a great safety net, but it also underscores the importance to have the appropriate documents in place to avoid that route.
Right. Okay. I think everybody has seen a movie or a TV show where somebody's writing their will on a napkin or a piece of paper. Is it legal to write your power of attorney on a napkin or a piece of paper as well?
So that's a great question. And the answer is no. Holograph wills, there's a very interesting body of case law on what constitutes a valid holograph will, which is in your own handwriting, signed by the testator, and you dispense with the formalities of execution by two witnesses.
Right.
Powers of attorney and personal directives are strictly governed by the Powers of Attorney Act and the Personal Directives Act. Okay. So those documents, those legislative schemes do not contemplate, something written out on a napkin. So once again, it's important to get these documents in place sooner rather than later. So you've got that peace of mind and you're not leaving family members scrambling in the event that there is an unlikely event of an accident or some form of injury.
Right. Okay. Earlier you mentioned enduring power of attorney. If somebody just has a regular power of attorney, not an enduring power of attorney, does that just look after certain financial transactions, or is it pretty broad-based as well?
Yeah, so typically what we see, the term a power of attorney and an enduring power of attorney are used interchangeably. Right. The enduring part simply speaks to the principle that this document will endure, notwithstanding mental incapacity. Where we see other documents that are called powers of attorney would essentially be the financial institutions. So banks will present a client with a document that says, should you lack capacity or should you want someone else to be your decision maker, here's who you're designating. And that would be limited to whatever assets that financial institution holds. It wouldn't apply over your cabin in BC, your house in Calgary. That would be very limited in scope. And we tend to advise our clients not always to enter into those types of arrangements, because then there can typically be conflicts. If there's that type of document with your bank, and then you've got a broader document that applies to everything, you can see how there could be conflicts between, what if they appoint different people? Who's in charge, right?
Yeah, I was going to ask you about that because years ago I used to work for a bank, and we used to have our clients complete powers of attorney. But if somebody has an enduring power of attorney prepared, and then their bank talks them into completing a power of attorney at that financial institution, and they name somebody different as power of attorney, which one takes precedent?
Right. And so we've got several litigious files right now that are, going through the court process. I'll just give you a war story on a no names basis here that might be of interest to our listeners, because of the fact that you've got elderly mom in her care facility. She has her documents that she executed years ago, while she had capacity, of course, appointing her niece as her decision maker. The niece lives in Calgary, very close relationship, loving family. Her adult sons live overseas, not in Calgary, don't often come to visit, etc. We peel back the layers of the onion. There's lots of turmoil in this family. Sons convince mom to execute new estate planning documents with a lawyer who she's unfamiliar with. Those documents get executed. Mom's getting into advanced dementia. And so we've got a problem here. We've got documents that appoint my client, and we've got new documents that revoke the previous ones and appoint new decision makers. Our view, based on the medical evidence and discussions with the family in the care home, is that she did not have capacity to execute the new documents. And so what does the bank do? The bank says, well, we've got this document that says niece is the decision maker. New documents say that the sons are. So we wind up in court over these types of issues all the time. And we're asking the court on medical evidence to make a determination of which document is the validly executed power of attorney. We don't see this dispute as much in personal directives. I think it's because, money is the driver for certain people and they want the control over the money. They want their hands on the money. I hate to sound cynical, but we're in court routinely on these types of disputes of conflicting documents.
Yeah, I find it amazing how money can divide families. The most loving or apparently loving family, when something happens and there's money involved, they can, the relationship can break down quite quickly. And it's kind of a sad situation.
My grandfather, who he's now obviously deceased, he died some time ago, but a wonderful man, a wise man, spoke Low German. And he had this saying that was in Low German that said, you never really know someone until you share an inheritance with them. Yeah. And isn't that the case? And again, we see these difficult situations all the time in our estate group at Carscallen, where we're, seeing families being torn apart over, we get the message, it's not about the money. Well, it usually is, but it's also about what happened when you were kids, who loved who more, who did mom favor, who did dad favor, where were the family dynamics? I think I often feel that I need more sort of training in the psychology behind these families and the social work field, because we're often just dealing with not always just strict legal concepts and principles, but actually helping families navigate through what's driving them to take certain positions.
Yeah, and that actually leads into my next question about how do you determine whether or not there's any coercion involved in the preparation of a power of attorney?
Yeah, that's a great question. And we apply a fairly strict, again, not being medical professionals and neuropsychologists, we've got fairly detailed checklists in our office that we use for, an understanding of what one's mental capacity may be. So we always like at a starting point to know who your client is. Who are we taking instructions from? It can't be from someone other than who's executing this document. Sure, more elderly people might need assistance making the appointment, getting to the office, but we always meet with our client by themselves. We don't like family members in the room. Sure, if a family member is dropping off and picking up or arranging for some payment from time to time, that is usually inconspicuous. But where we feel like someone other than the client is instructing us or driving some sort of agenda, that always brings up the red flags of undue influence in suspicious circumstances. So our checklists essentially involve, I always like to meet people in person. I know COVID has made that really challenging, but we've gone to almost every care facility in the city, I think, in the last 2 years, because we've been meeting people in their care homes and in their homes if they've decided to stay there. And you ask them very basic questions about their assets, what they want to do with those assets at the time of their death, who are the family members, sort of scope out the family tree, and get a really good understanding for what it is they want to have happen in the event of incapacity, and when making a will, of course, in the event of their death. So when we do a deathbed will, as I call it that, where someone really wants to make some changes quite quickly. That happened to me last month. I had a very good client of mine, and she was diagnosed with a very serious and sudden terminal cancer, and she was down in Lethbridge. We did everything very quickly over Zoom because this was so sudden. I had absolutely no concerns that there was undue influence or she didn't have mental capacity. She was medicated, of course, for her pain. But in that circumstance, we've got a very detailed checklist that we go through. And if there are any doubts of capacity, we would always like to speak with a doctor, caregivers, to make sure we've just got a solid note and memo on our file that we were confident that we could take instructions to make these new documents. Sometimes we're skirting the edges here where you want to honor these people, the client's wish, but you need to make absolutely sure that this will could not be challenged after they pass away.
Yeah, it'd be kind of not a tricky situation, but a situation where you really have to be careful with the person's mental capacity and that there isn't coercion. How about an enduring power of attorney prepared? Is there any legal requirements? Do I have to be of a certain age, or is there a maximum age, or is it just based on capacity?
Based on capacity, I'd have to double check on that. I do believe it's the wills are a little bit different because if you're in the military, I believe you can make a will if you're 14, otherwise it's 18. Personal directives and power of attorney, I do believe it's 18. There is no maximum on who can execute those documents. Once again, we've got people well into their 90s that are, making changes. So long as they've got the mental capacity to do so. It's also an interesting, discussion about capacity is so task specific. You might have the capacity to make an enduring power of attorney, but the standard for making a will is somewhat higher. And ironically, in the law and how these tests have been applied, you need the lowest mental capacity on the scale or the spectrum to get married. Isn't that interesting?
Wow. That's really interesting.
So it's a fascinating area to talk about. What constitutes a lack of capacity? Is it medical? Is there also just people, individuals being vulnerable to financial manipulation? I mean, especially throughout COVID, and I know my colleagues would agree, we've seen a huge rise in elder financial abuse claims. Yeah. Again, the example of, an older person being taken out to a new lawyer, a new bank, signing over accounts into joint names, executing new documents. And it's been quite shocking and staggering to see the number of financial elder abuse claims that we're now litigating to say, look, you've taken this person's money. They have capacity in some areas, but not in others. Mm-hmm. We're seeing e-transfers come out of accounts, unauthorized use of credit cards. And it's so upsetting to know that the most vulnerable in our population can be so easily taken advantage of.
Yeah. Can the person that granted the power of attorney to, say, their son, is there any legal recourse against the power of attorney if they do something, questionable, I guess, or if they make an error and it results in a loss of some sort?
Yeah, absolutely. So the Powers of Attorney Act provides for a duty to account. So anyone acting as attorney or purporting to act as an attorney must provide an accounting to interested persons. So sometimes we fall into a debate about who is an interested person, who has the standing or the entitlement to ask for that accounting. But because attorneys, much like executors and trustees under wills, are held to such a high standard of care, so they are fiduciaries, mm-hmm. They owe a very high duty to use the funds only in the best interests of the party granting the decision-making power. They may not give gifts, they may not change wills, they may not change beneficiary designations on accounts. They must stand in their shoes and do whatever they could do, but they cannot personally benefit. So one issue that we run into is an attorney that may want to give some gifts. Let's say caregivers, let's say nieces, nephews, grandchildren. Well, you have to be very careful. In our drafting, we always spell out, once we understand what the client's instructions are on that, we want to be very clear on what gifting is. Because all of a sudden, I have run into these very unfortunate cases before where, the attorney says, I took my kids on a cruise to Florida because that's what mom would have wanted, and we used mom's money to do so. But mom has dementia sitting in Calgary. I mean, that's a really, really dangerous line there, because it's like, well, what mom can't express her wishes. And the idea that you as an attorney are potentially benefiting from your role, you have to account for every penny that you spend. That goes in and goes out. I had another one where the attorney, the son, had mom propped up at the VLTs at the Carriage House Inn. And mom was in her 80s and mom wasn't into VLTs, and their son using all mom's money to do his gambling.
Oh, that's amazing. It's sad and amazing. So, what about, so the power of attorneys misuse their authority. Can a beneficiary or someone that would be a beneficiary in the will challenge the power of attorney?
Yeah, that's such a good question, Gary, because oftentimes we run into this. And the thing is that the personal directive and the power of attorney both cease to be effective on death, because they're only in effect when someone is alive. Okay. However, the duty to account for decisions made while someone was alive endures beyond death. So we have a file right now, and we can say, okay, he's passed away, the gentleman passed away a couple of years ago. However, in the course of administering his estate pursuant to his will, we discovered that there's like $1 million or more not accounted for. Well, where did this money go? A house was sold. Where are the house sale proceeds? Accounts were consolidated and liquidated. Where did all that money go? So then we have to work with him, which obviously led to litigation. He retained counsel. We had to bring the formal application to have him account, because, when you think there's $3 million there and there's only 1.5 or 2, this person who acted as attorney has to account. Because that will impact, obviously, the beneficiaries under the will. So that is something that we do routinely, unfortunately, but we see those applications all of the time.
Yeah. Okay. If I have a power of attorney, an enduring power of attorney for property prepared in Alberta, and I move to Ontario or BC, is it still valid, or do I have to have another one prepared in that jurisdiction?
Right. So we were speaking on this recently at some Legal Education Society of Alberta conferences, because oftentimes we do see clients who've got property in BC and property in Alberta. The general rule is that if a power of attorney executed in Alberta meets the execution requirements in, let's just say, BC, for example, a new BC power of attorney would not need to be prepared. BC would honor the Alberta power of attorney. Now, I've got some clients in Kelowna who've built a house there, and they want to, they've also got property in Calgary, but they, did want to cover all the bases. In their circumstance, we decided to do powers of attorney in both jurisdictions. And that's fine. It doesn't always need to be done that way. But we would certainly only recommend one will being done per jurisdiction. You do not want wills and other, you don't want one or more wills floating around out there, whether they're in Ontario or BC or what have you. That's just adds to, or, invites a lot of complication.
Yeah. If I have a power of attorney, so let's say I've named my brother as power of attorney. Let's say that he's named me as power of attorney. Okay, and I also have a power of attorney naming somebody else, and I go away and have an accident, so I can no longer look after my brother's power of attorney because I'm incapacitated myself. Does my person that I've appointed as power of attorney then look after my brother while I'm incapacitated?
Potentially, it would first of all depend on what your brother's power of attorney says. So typically in our practice, and it's our recommendation, you have a primary or two or three, which again can be too many cooks in the kitchen. We always like to have one with an alternate. If your brother had an alternate named after you, that person would act if you could not. If there is no alternate, I think it could potentially fall on the attorney that you've appointed in your document to handle his affairs. Now, that could be 6 degrees of separation, and there could not be any knowledge of what, the finances are like and what his wishes would be. So I think this scenario that you've described underscores the importance of having a primary attorney or attorneys and then backup.
Right. Yeah, that makes a lot of sense, because otherwise, like you just described, a perfect stranger could be responsible for somebody's financial affairs, and that could be quite.
It could add layers of complexity and confusion that could be avoided if you've got the proper alternates in place.
Okay. The powers of attorney, they can be revoked and redone and stuff like that. So nothing's carved in stone. Is a power of attorney a public document though, or is it private?
It is private. We don't have a wills registry or a registry for these types of documents in Alberta. Ontario, I believe, has a vast wills registry system. We do not. So to the extent that you would want to, when we have our clients in to execute these documents, we do one will, which typically would stay in our firm's vault. We give electronic or hard copies or both, whatever the clients prefer. And then we keep an original power of attorney and a personal directive. And we also give our clients 2 originals each, so they can pass those along to the decision makers that they've appointed. So again, no one's taken by surprise. Everyone's got a copy of what the documents are in force when they're executed. And again, that speaks to my earlier point about my inclination is to always have, more open communication than not. So no one is saying, oh, wait, I was appointed under this document. What do I have to do? What are my obligations? It can be quite stressful under already stressful circumstances.
Right. So as a law firm, is it your responsibility to let the power of attorney know that they've been appointed, or is it the grantor of the power of attorney?
Yeah, so that's an interesting one. Typically, we would never have an obligation as counsel to advise decision makers of their role. We encourage our clients to share that information. But if we were to do so without our client's consent, I think that would be a violation of solicitor-client privilege. So I always encourage, as a team, we encourage our clients to say, okay, you've thought about this, you've appointed these decision makers. You should have a discussion with them so they know exactly what it is they could be. And maybe these documents will never need to be used, right? They're there as a safety net, and they're there for family, to protect the family and protect the assets and making sure that all the appropriate decisions are being made. But it certainly wouldn't be our duty unless my client says to me, please reach out to my daughter or my son or my family friend or all of the above and advise them of, the client has to instruct me to make that communication. And I'm happy to do so, but I can't do it without their authority and their express consent.
Okay. What happens if the person granted as the power of attorney doesn't want to be? It finds out, like, just out of the blue, that, hey, you're the power of attorney, but doesn't want to be, or has maybe predeceased the person granting the power.
Right. So our documents always contemplate that on the death, refusal, or inability of an attorney to act, so and so is appointed. So no one is ever forced to take on this role, but it is very important for them to know that if they are advised that they're in this role, they shouldn't take any steps if they don't want to act. Because if they take steps to do things and to manage affairs and to move money around and sell property, they can't just be discharged if they decide they don't want to do it.
Right.
So it's akin to an executor renouncing their authority under a will. You have to swear an affidavit that you've not taken any steps to intermeddle in an estate. Mm-hmm. A similar principle applies with enduring powers of attorney, where you say, okay, if you don't want to do this job, fine, you can resign, you can renounce, but you better not have, done anything that could jeopardize the administration of the affairs, because then you'd need the court's order to be discharged. And that can become very litigious and complicated depending on the file and the circumstances.
Yeah, no doubt. So am I correct in assuming that it would be best to have the power of attorney in the same city or at least nearby, should something happen and powers kick in?
Yeah, so with technology now, and especially through the pandemic, there's certainly no requirement that your attorney has to be in Alberta if you're regularly domiciled there. We'll have, kids appointed who live in Ontario, kind of all over the country. It's typically easier, but with technology nowadays, it's certainly, I think, more manageable. Mm-hmm. My earlier example of the family members that were living in the UK, I think that makes creates further challenges with respect to, time zones and travel. And what if someone needs to really be like boots on the ground to figure out where mom's going to live? Is she going to move? Well, who's going to move her? Who's going to look after cleaning out her condo? Who's going to look after paying of utilities? There's certain files will benefit, I think, and families will benefit much more from having someone that's local, but it's certainly not something that I would say, if you're not in Calgary where mom lives or in Pritis where mom lives, that's a hard and fast rule. Again, it's a little bit, I would say, family specific. Okay,
just a couple more questions, Jen. Let's say that a power of attorney or the person lives in Alberta, but the power of attorney is in Ontario. Something happens, the powers kick in, the person from Ontario flies out to Calgary. Can they charge the grantor? Is there compensation or is there a reimbursement for their costs to come out here?
Yeah, so the document, in our practice, the document should speak to that. The typical sort of rule of thumb is that attorneys get reimbursed for reasonable expenses incurred as a result of carrying out their duties. But typically, my clients don't want their attorneys to be charged for their time, like on an hourly basis. It's sort of saying, look, you're doing this for me. It's an act of love. I think that's what you said earlier, Gary. That's a great analogy. That's not to say that attorneys can't be compensated, because they can be, but it's more what I see in my practice is making sure the document speaks really clearly to both compensation and reimbursement. I think reimbursement of expenses are travel, mileage. Oftentimes you're buying things for the donor, the family members, so they need personal items, moving costs, storage costs, things like that. Now, if you're in Calgary and you're from Ontario and you're taking all your friends out for dinner because you came to see mom and move mom, I'm sure that's not a reasonable expense. However, I've seen it. I've seen it try to be reimbursed. So I think you have to exercise really good judgment. And again, knowing that you can be reimbursed for, expenses that you're incurring for the benefit of mom. Right. Just to use her mom as the example. So
yeah. I thought of another question, but I want to ask this one. When it comes to appointing powers of attorney, what happens if there's like an even number, like let's say somebody's appointed 2 powers of attorney to work together or 4, and there's a dispute. There, half the group wants to do one thing, the other wants to do something else. How is that resolved?
Right. So there's 2 different ways to go about that. When I've got a client in my office and they say, well, let's just use my mom as an example. So there's 3 of us sisters, and mom wants all 3 of us to be appointed. So there's one option. We all have to decide together. We all have to agree.
Okay.
And if we don't agree, I would recommend we build in a majority rules clause. So whatever the 2 versus 1 decide is what happens. What becomes more tricky is when, let's just say it's myself and one of my sisters appointed. What if my mom says, well, Jennifer can make decisions and Susan can make decisions. They don't have to agree. That's a nightmare. And I see that oftentimes because you just may not agree on how mom's GICs should be reinvested if they come up to a maturity date. How should mom's condo be sold or her house be sold? Should her car be sold? So when there's more than one attorney, I often recommend that you must act together. The problem is that you will run into conflicting ideas, conflicting decisions, and then the bank will say, for example, well, I've got instructions from Jennifer and I've got instructions from Susan and they don't conflict. What do? They can't agree. So we really like they must act jointly versus jointly and severally. So that when you get beyond 2 attorneys and there's 3, and this applies to a will, this applies to a personal directive, I would always recommend a majority rules clause. So you break the tie, because if there isn't that in there, you're at a stalemate.
Yeah. Then families will break apart, So the parent doesn't have to pass away for families to start fighting. They can fight when the mom's still alive.
Exactly.
Okay, it looks like we're just about out of time. Thank you again, Jennifer, for providing such valuable information and insight and giving us a lot of things to think about when it comes to powers of attorney. Very much appreciated. Jennifer, how can our audience get into contact with you?
Well, that's great, Gary. Thank you so much. I just really appreciate the opportunity to discuss these matters today, and I'd like to continue the conversation with anyone that's interested. I know these are not often easy topics to tackle, and if anything, we tend to procrastinate when it comes to these difficult decisions and conversations. I'd be more than happy to hear from any of the listeners. My direct line at Carscallen is 403-298-8455. And my email address is just my last name, Lamb, Lamb, at, and again, the name of our firm is Carscallen. So it's at Carscallen.com. And I'd be more than happy to chat through any of these issues with any of our listeners. And again, I'm really honored that you invited me on the podcast today, Gary. I really appreciate it.
Well, we appreciate your time and your knowledge as well, Jim. Again, I just want to remind our audience that our sponsor is Customplan Financial Advisors. They are an award-winning MGA based out of Vancouver, but with Canadian presence. And you can visit their website at customplanfinancial.com. This podcast, along with all the other podcasts, will be available on YouTube and on Spotify, as well as at financialpodcast.ca. You can subscribe to receive notification of new podcasts by visiting financialpodcast.ca. And if you have any questions or if you have any ideas or someone who you think would make a great guest, please send us an email at contact@financialpodcast.ca or info@financialpodcast.ca. We'd also love to receive your feedback, so you can contact us again at contact@financialpodcast.ca or info@financialpodcast.ca. Thank you again, Jennifer. You have a great day, and everyone else have a fabulous day as well. Thank you.
Thanks so much, Gary. Thanks, everyone. Have a great day.
The views expressed here are those of the participants and not those of Customplan Financial Advisors, Inc., its affiliates, or subsidiaries. This is not intended to serve as a complete analysis of every material fact regarding any company, industry, or security. This presentation may contain forward-looking statements. Investors are cautioned not to place undue reliance on such statements, as actual results could vary. This site and podcasts are for general information purposes only and does not constitute investment advice and is not intended as an endorsement of any specific investment product or service. Individual investors should consult with an investment professional about their personal situation. Past performance is not indicative of future results. If you are unsure about what is the best course of action for you in your financial planning, then we suggest you consult a fee-based independent financial advisor or get in touch with us to discuss your individual situation. Our phone number is 604-687-7773.